So as a workers' compensation attorney, our office fields a lot of calls from folks who have been hurt on the job. And it really does pain us when we have to tell folks that, look, my friend, you made a mistake, and unfortunately we can't bring a claim for you. We're going to talk about the top 5 mistakes that people make when they bring a workers' compensation claim. I'm Joe Miller, workers' compensation attorney in Virginia, North Carolina. I want to say hello to you, and I hope you'll join us for this video. We're going to count them down. So we're going to start with mistake number 5. Make sure you tell all your healthcare providers that you got hurt at work and how you got hurt at work. Give them the information about who your employer is and all of that. You go to the hospital, you go to the doctor, and after your injury, and maybe you want, maybe the employer is encouraging you, look, let's not report this. I want to keep my premiums low, what have you. You got hurt pretty bad, but you tell them at the emergency room, and you tell the ambulance driver, I did this at home. Just put down that I did this at home. Or you get to the emergency room, somebody takes you to the emergency room, and you tell them that you got hurt at home, or you don't mention anything about getting hurt at work at all, or you don't properly give over a good description or history of how you got hurt at work, okay? And that, I'm here to tell you that can mess up your whole case. When you if you have to go to hearing if the claim is denied, particularly, or this will actually cause it to be denied, the claims adjusters who look at these claims, they're looking for consistency. They're looking for, did you tell this doctor what happened, and did you tell him how it happened the right way? Did you tell him you got hurt at work, first of all? Second of all, did you tell him how it happened, and did you tell him right? The next thing is, did you tell the next healthcare provider the same thing, or did you tell them something different? And so they're looking for consistency across the board. If they don't see that consistency, then you're going to lose your case. And that's how this works. So you want to make sure you're telling them what happened. You need to tell them the exact same thing to each healthcare provider, not something different. I've had folks come to me who tried to play along with the employer after a very long time of treatment. Maybe they even got their treatment paid for, but now they're disabled from work. And they come to me, and I look back at the medical records, and good gosh, there's not a single mention of being hurt on the job. We got a problem. Okay, that's number 5. Number 4 is, once you're hurt, they have you, the workers' compensation folks want to have you go to one of their doctors. And you either refuse to go, or you just don't go at all, or you pick some other doctor. Many folks make this mistake, and they just say, I'm not seeing anybody you want me to see, or they're in the emergency room. There's a lot of different things that ways this can go down. The bottom line is you're refusing to play along with the workers' compensation folks. Now, in North Carolina, you must do this. In North Carolina, the insurance company really has absolute control over who you treat with and where you treat. Virginia, you have a little bit of control. If you need to see a certain type of healthcare provider, then you get to ask for a panel of 3 different providers from which to choose. But what you can't do is say, no, I'm not doing any of that. I'm going to my doctor who I like. You're not allowed to do that. Not only are they not going to pay for it, but a lot of times they'll deny the claim because they'll say that you refused proper medical treatment. And yeah, at the end of the day, you may win the claim, but you're going to have an uphill battle. Okay? Mistake number 4. Let's go to mistake number 3. There's something that we often see called an award agreement. An award agreement means that basically you have won your case. And what happens is we get a lot of calls from folks who say, I got this paper in the mail, 6 months ago, what have you. I knew better than to sign it, or something like this, we'll hear. And we tell them, very nicely, kind of want to say, you idiot. But we don't say that, of course. We tell them, it would have been a good thing if had you, assuming that all the numbers and everything that was filled out on the form was proper, it would have been a good thing if you had called us and we would have told you, 6 months ago to sign this paper, because that would have put you in a situation where right now you would be under an award in Virginia, which means that you would be pretty much bulletproof as far as your checks being cut off once you're returned to light duty. Okay? Now you put yourself in a situation where you don't have an award because you didn't sign the paper that says that they are agreeing to the claim. So that's the third biggest mistake we see. People get an award agreement, they don't know what to do with it, they don't call anybody about it, they don't realize that this means that you've won your case, and they don't take action. I encourage you to watch my videos on what an award means in Virginia. Okay, that's number 3. Let's go to number 2. We're counting them down. We're down to number 2 now. So what's the second biggest mistake that we see? Waiting too long to file a claim. In Virginia, there's a very simple thing called a claim form that you need to file to get the claim going. In North Carolina, there's a similar form that's called a Form 18. If you wait too long, let's say they paid for your medical treatment, maybe you're back at work, maybe you're not back at work, whatever the situation is, but they paid for it, you didn't figure there was anything that you had to do. Oftentimes we will hear this from the employee. They'll say, well, my employer told me they took care of it. There is no such thing as your employer filing your claim for you, or the insurance company filing your claim for you. Now, what they might be referring to is what's called a first report of injury. That is their obligation. That is the employer's obligation. You have to file your claim within 2 years of the accident, okay? In most cases, if you don't do that, okay, it's finished. Let's look at this scenario. It's been a little over 2 years since the accident happened. You haven't missed any time from work, really, but now things have gotten bad. Your doctor wants to do surgery. It's time to take you out of work. You haven't filed a claim, and you go ahead and say, okay, I want to go ahead and be taken out of work now, and I want some money for the time I'm out of work. The insurance company says, too bad, so sad. You didn't file your claim on time. It's called the statute of limitations. They plead the statute of limitations as defense, and guess what? They're going to win, and you're not going to have a case. I have another video where I tell them about probably the most egregious situation I ever heard, where somebody had a hand cut off at a factory, and they went 10 years without filing a claim, and then they were fired. So they missed out on so much. They missed out on the loss of the hand that they could have recovered for, the prosthetics that they would have been entitled to, all gone. You have a limited amount of time to file your claim. The other thing is, if you go in Virginia, if you go 24 months, let's assume that they've paid you something, okay? If you go 24 months without filing again to get paid, then you're finished. It's 2 years from the date of the accident. Let's just keep it simple. 2 years from the date of the accident, you want to file your claim, okay? Okay, so that's number 2. Let's go to number 1. What is the number 1 thing that we see, the number 1 mistake that folks make that are hurt on the job? And that is quitting. It is the worst thing that you can do, almost the worst thing that you can do to your claim. We understand it, it happens. Why? Because the employer may not be treating you right. The employer may be acting, they're ignoring your injury, they're not listening to you, whatever. People get frustrated, they get aggravated, and they quit. I've even seen people who are severely injured and in the hospital, okay? And the employer tells them, oh, I don't know what we're gonna do without you. We need to fill this position, my friend. And they say, well, I'll help you out, I'll quit, and that way you can go. Don't ever do that. Please don't do that. What you've done if you've quit, you have handed the defense their victory. The only time you're going to be able to ever recover any money is if you're held completely 100% out of work. If you're ever put on light duty, you never get a penny. Why is that? Because the reason you are out of work is not because you're on light duty, it's because you quit your job. The employer is going to say, hey, we had a light duty job for the guy. Maybe they did, maybe they didn't, but they can say that. And if they say that and you quit, you're out. So don't quit your job. There's no reason to do it. If the employer says, look, we can't accommodate you, let them say that. Your claim remains intact. That has nothing to do with you quitting. But if it comes from you and you quit, you've just given away your case. Don't do it. So those are the top 5 mistakes that we hear folks make all the time. I hope this video has been helpful for you. I hope the information has been helpful for you. And I hope you don't make any of these mistakes if you get hurt on the job. If you have any questions, if you've been hurt on the job or you or a loved one been hurt on the job in Virginia or North Carolina, please don't hesitate to give us a call. Be happy to talk to you, be happy to help you. Joe Miller, workers' compensation attorney. God bless. Stay safe.